Good afternoon. My name is Tan Yin Chi. I'm here today to talk about the extent to which it would be possible to attribute authorship of copyrighted works created with the aid of artificial intelligence to a human being. In recent times, technological advancements in light of AI have enabled newly invented machines, programs, and systems to generate original content across various media. This has raised interesting questions as to the ownership and infringement of AI created content under copyright law. This is the case since in the machine learning area, sophisticated AI is no longer solely dependent on human instructions and can apply logic, make contextual decisions, automatically perform tasks, and simultaneously process and interpret a large quantity of data. This ultimately means that humans are no longer the sole creators of creative and innovative work. While determining the owner of or creator of a man made work is typically quite simple, challenges occur when dealing with works generated by artificial intelligence or AI. AI created works copyright protection can be addressed in the following ways. States may altogether deny any copyright protection to works created by AI, like in the United States. States may attribute authorship of the works created by AI to the AI itself, like in China, or states may attribute authorship of works created by AI to the creator or creators of the program, like in the United Kingdom. In most countries, only a natural person may be deemed the creator of a copyrightable work. Let's first take a look at AI authorship in the United States. Although the word writings is susceptible in interpretation under US copyright law, many AI generated works frequently fall outside of its reach by failing to meet all of its conditions. In reality, creative works made entirely by AI algorithms are not copyrightable if they do not meet the Copyright Office's human author criteria. In other words, unless AI generated works can clearly be credited to a human author, they are not copyrightable and enter the public domain upon production. As the copyright requirements listed by US Copyright Office states, the office will not register works produced by a machine or mere mechanical process that operates randomly or automatically without any creative input or intervention from a human author. This makes works created by an AI machines for which the human author of the machine is not directly responsible fall into the public domain. There is, however, a significant drawback to the release of autonomously created AI creative works into the public domain. There is no practical reason for AI machine creators to continue building, utilizing, and expanding their capabilities in absence of a fixed term of protection. This is seen in Sony Corporation of America against Universal City Studios Incorporated, or the Betamax case. The Supreme Court ruled that limited benefits associated with copyright ownership are intended to motivate the creative activity of authors and inventors by the provision of a special reward and allow the public access to the products of their genius after the limited period of exclusive control has expired. So denying copyright to AI machine creators and owners diminishes their incentives to produce new AI programs, which may eventually lead to a decreased quantity of AI created copyrightable works and a significant drop in works entering the public domain. On the other hand, the United Kingdom's approach is to give authorship to copyrighted works created with the aid of AI to the programmer. According to Section 9, Subsection 3 of the Copyright Designs and Patents Act, the CDPA, in the case of a literary, dramatic, musical, or artistic work which is computer generated, the author shall be taken to the person by whom the arrangements necessary for the creation of the work are undertaken. Furthermore, Section 178 of the CDPA defines a computer-generated work as one that is generated by computer in circumstances such that there is no human author of the work. The idea behind such a provision is to create an exception to all human authorship requirements by recognizing that the work that goes into creating a program is capable of generating works, even if the creative spark is undertaken by the machine. According to certain case laws, this matter may be resolved on a case by case basis. In the English case of Nova Productions against Mazuma Games, the Court of Appeal had decided to on the authorship of a computer game and declared that a player's input is not artistic in nature and he has contributed no skill or labor of an artistic kind. So considering user action case by case could be one of the possible solutions to the problem. Moving on, the concept of assigning human authorship to computer generated works may be traced back to the UK CDPA. Professor Anne-Marie Briddy, for example, endorses the United Kingdom's viewpoint by proposing a change to the United States Copyright Act's created for hire theory as a means of transferring copyright to a human author. One of the most successful approaches to allow transfer of AI generated works to human writers is to use a relative interpretation of the phrases employee and employer under the created for hire doctrine, rather than rigorously defining them in line with agency law. There are three possible parties which may have claims to the copyright of AI generated works: AI programmers, owners like large companies and financial investors in the AI sector, or end users. When choosing the best potential author, the entire societal benefit of the copyright attribution procedure must be considered. In other words, would society profit more from assigning copyright to the AI programmer, the entity is responsible for supporting AI development, or the possible millions of end users of the AI programs? Since end users contributed the least to the original creation of AI, their claims to authorship are the least persuasive. Providing incentives to AI programmers and owners would be the logical solution to ensuring sustainable growth and development to the AI sector. In conclusion, things are expected to grow much more complicated as the use of artificial intelligence by artists become more popular and as machines improve at generating creative works, blurring the line between artwork created by humans and artwork created by AI programs. This distinction may be rendered irrelevant by monumental improvements in computers and the sheer quantity of accessible computational power. When you give a machine the ability to learn styles from enormous databases of information, it will get better at impersonating humans. Granting copyright to the individual who made artificial intelligence conceivable appears to be the most logical method, with the UK model appearing with the most efficiency. Such an approach will guarantee the businesses continue to invest in technology and it will be certain that they will see a return on their investment.